Hello, dear students. As we had discussed in the class, that I'll be sending you two topics recordings for you. That is, one is the Limited Liability Partnership Act 2008, and the other is the companies incorporated outside India and having the place of business in India, that is the foreign companies. Okay. So first, I'll be starting with LLP 2008, and then we'll have the next recording. I will do these recordings in part small pieces for you, so that wherever you read it, you'll be having small portion to be covered with at your end. What you will do is, we'll have the same approach as that in the class. And as I explained in the live classes itself, I told you, even the recording which I'll be doing will be in the same way how the class is taken. So what you should do is, the study text that we have used in the class, that you'll be having in front of you. And when I'm doing it, see that parallelly, you do it along with me. Okay? There should be, the way in which we are going to take up the session should be such that, you finish learning it along with me. Do not keep it pending. So when I'm discussing with you the chapter, see that the learning is then and there completed. Because this is not a brand new thing for you, you have already studied as a part of CA in foundation. I think grasping it is going to be very simple. So please do not spend additional time on it. In the class with me, please finish studying. And see that after that, if you want to just go through the pages at a glance, you can do it. Okay, because now you're at the crucial stage of your examination, where really you cannot afford of listening to the lecture first and then having an additional time for preparation also. So please, with utmost concentration, take the topic 100% now itself with you. Okay, so let us begin our discussion with LLP 2008. That is the Limited Liability Partnership Act 2008. So we should understand that there was a time in India where we have seen that companies were flourishing. We also knew that partnership was there. But then company had its own problem of having so much stringent rules and regulation, and the compliances were very difficult. On the same lines, when you look at a partnership, the formation is very simple, but it has a very big problem of unlimited liability. And that is the reason professionals, especially chartered accountants, cost accountants, etc., who wanted to start something of their own, would find this a little difficult thing, because there are some things which CAs cannot do if they're doing in the form of a company. And they will not be able to, have their comfort in the partnership because of the unlimited liability. Because of which the government of India realized that yes, there is a need for another corporate vehicle to come up. And this corporate vehicle was the limited liability partnership, which is a hybrid between company as well as the partnership. This is some elements of companies being picked up and some elements of partnership being picked up. And then totally, when you bring them together, there comes this concept of LLP. So in the year 2007, the LLP, or basically you can say 2008 around, the LLP bill was passed, okay, which the president gave the assent in 2009 and called this bill to be LLP Act 2008. Okay. From then on, we have a separate body corporate altogether, which we call it to be a limited liability partnership. And you should be very well aware of it, because when you talk about Big Fours, PwC, KPMG, all of these are actually operating in the form of limited liability partnership. Okay, so what we are going to study in this particular chapter is first the basics of it, the background, how it came into picture. What is the basic idea about LLP? What different types of partners do we have? Then throughout LLP, there are multiple words used. So we are going to study the definition of certain terms here. Definition why we are studying is because when you talk about these particular words like body corporate, etc., they have a very meaning by themselves. Okay, but when you use it in LLP context, then they are going to have a limited meaning for it. And that is the reason they have given a definition section for us, wherein we are going to understand meaning of certain terms. That means in LLP Act, when you're going to use those terms, they would simply mean as defined by the LLP Act. Then we are going to discuss about the incorporation of LLP, features of LLP, what will happen if there is a constitutional change in the LLP, that are partners coming in, partners going out. Then we have the concept of whistleblower. And finally, since we have discussed about incorporation, we also have to understand about the dissolution. So we are going to understand about the winding up of the LLP. Okay, so things are going to be very simple. The act is really easy. So be with me throughout the chapter and see that you complete it along with me. As I told you, other laws have not to be taken lightly, because in the exam, if you really think of scoring somewhere, it is going to be the other laws only. So see that this act also is done with utmost sincerity at your end. Okay, so let us get started. I'm having the Abhishek Bansal book with me. I always give the wrong name. Yeah, Abhishek Bansal with me. Okay, you should also have the same one, and we are going to follow it throughout. Okay, so we have the chapter 17 with us, which is the Limited Liability Partnership Act 2008. Now, if you look at the introduction, I told you that this bill was passed in 2008, that is 12th of December 2008, and the president gave the assent on 7th of January 2009 and called this act to be an LLP Act 2008. So first particular paragraph is simply talking about, first we always know in the Indian law how it is. First a bill comes up and then president gives this assent and that becomes an act. So 2008, the bill was passed. 2009, president gave the assent, but called the act to be LLP Act 2008. And all the provisions of LLP came into picture by, or came into enforcement on 31st of March 2009. There was slow and steady being applicable. Then you will see that this act have been incorporated to make provisions for the formation and the regulation of LLP and the matters connected thereto. So I told you there was a need for this new act to come in. Why? Because if somebody wants to form an LLP, how they are going to form? If they want to understand how we have to file the documents and everything, where to form, how to file it, which forms to be filed, all of this thing is covered by the LLP Act. Correct? Then, if you look at the structure of the LLP Act, it has 81 sections and 4 schedules. Like when you talk about Companies Act, we discuss about the sections in 450s around, and then we say 7 schedules are there. Similarly, here we have 81 sections, all are not covered for your syllabus, and you have 4 different schedules. So first schedule is talking about the mutual rights and duties amongst the partner. So basically, because LLP is like a partnership, this also has an agreement. So partners among themselves are going to have an agreement. However, if the agreement is silent somewhere, here we are going to take the mutual understandings coming from where? The first schedule. So if you look at the English of the first schedule deals with mutual rights and duties. Mutual means amongst each other, okay, of the partners, as well as that of LLP. See, LLP is a body corporate. So it is different from its members, correct? So what members have the right towards the LLP? What LLP has the right towards the partners? What partners has the right towards each other? Mutual is amongst the partners and with LLP and the partners. What is the right? All of these things will be discussed in the first schedule if there is no agreement to the contrary. That means if there is an agreement, agreement will prevail. If not, we are going to take it from where? The first schedule. So as well as limited liability partnership and its partners. So where there is an absence of formal agreement with respect of them. That means 2 things are there: mutual rights and duties of the partners and rights and duties between LLP and the partners. But however, this will operate only when there is no agreement to the contrary. So if there is an agreement, agreement will prevail. If not, we take it from where? The first schedule. Then we have the second schedule, which deals with conversion of firm into LLP. Today, if there is going to be a partnership firm which wants to convert into LLP, this will not be given in the Partnership Act. It will be given where? In LLP. And where? In the second schedule. Then the third schedule talks about conversion of private company into LLP. So if private company wants to convert into LLP, provisions are not given in the private company in the Companies Act. They are given where? In LLP. So you have to refer to the schedule 3. Then when you talk about the fourth schedule, it talks about conversion of unlisted public company. So unlisted public company, if they want to convert into LLP, provisions are not available in the Companies Act. They're available where? In the LLP Act. Correct? And that is where? In the fourth schedule. So very simple. First schedule is mutual rights and duties amongst the partners and between LLP and the partners when absence of agreement to the contrary. Second schedule, conversion of partnership firm into LLP. Third schedule, conversion of private company into LLP. Fourth schedule will talk about conversion of unlisted public company into LLP. Concept of listed public company to LLP, not possible. Okay, then. The MCA and the ROC are entrusted with the task of administering the LLP Act 2008. Meaning is, we don't have a separate registrar for LLP. So whosoever is doing the activities for a company, like we say, companies have to file the documents with ROC. Company has to upload the documents with MCA. Same thing here. When LLP is to be formulated or LLP has to be submitting their documents and all, they will be still governed by whom? MCA and ROC only. So we don't have registrar of LLP. It is still registrar of companies who's going to deal with the matters of LLP also. Then we have the central government has the authority to frame the rules with regard to LLP. So obviously understand LLP also will have LLP rules, and we know LLP rules will be 2009, correct? So these rules, central government, as and when they require, will come up with the rules. How? By giving a notification in the official gazette. I think this part is quite simple. So one reading also you'll be able to remember. 81 sections, 4 schedules. 1 talks about mutual rights, 2 conversion, 3 conversion, 4 is conversion. Okay, then ROC and MCA still governs LLP. And most importantly, we also have that LLP rules will be made from time to time and they'll be released by whom? Central government. LLP is a central act. So rules will come from where? Central government. Clear? All right. Now comes to limited liability partnership, meaning and concept. I told you it is a hybrid between company and partnership. Okay, so they say LLP is a new form of legal business entity with a limited liability. It is an alternative corporate vehicle. Alternative means something different which came up, which not only gives the benefit of a limited liability at a low compliance cost, but also allows its partner the flexibility of organizing their internal structure as a traditional partnership. So you can have an internal structure that is agreement as good as a partnership, and also you'll have low compliance cost, and you'll enjoy the benefit of limited liability. So you'll see how many benefits are there here. So they'll be having limited liability, low compliance cost as that compared to the companies. And when you talk about ease of formation, an agreement is to be entered. So internal rules and regulations are not going to be very stringent. You'll be having a traditional partnership, how you form, same way you have to form the LLP also. Correct? Then the LLP is a separate legal entity because it is the body corporately understood. And while LLP itself will be liable for the full extent of its assets, the liability of the partners will always be limited. Because one of the benefits of forming LLP is what? Limitation on the liability. LLP is an alternative corporate business that gives the benefit of limited liability of a company and flexibility of a partnership. The point is getting repeated. Since LLP contains both corporate structure as well as partnership firm structure, LLP is called as hybrid between a company and a partnership. Simple? Yes. Now, the next one is small limited liability partnership. Please mark it very important for the upcoming examination. You would definitely have a question here. Now, all of you have to go back to the Companies Act where you have studied the definition of a small company. So you study section 2 clause 85 where we discuss about what is a small company. And in small company, we look at two parameters. One, the paid up capital, other is the turnover. And if both of these conditions are fulfilled, we call a company to be a small company where they have some specific rights and duties and the way of operation. It's a different type of private company. Similarly, in LLP also we have this concept where we say there is a small LLP through which a lot of exemptions are given for compliances to the small LLP. Okay, so look at that. LLP, what is small LLP? It means limited liability partnership, the contribution of which, contribution means capital. So there also we had paid up capital as a limit first. So here it is, the contribution of which does not exceed 25 lakhs or such higher amount not exceeding 5 crores, okay, as may be prescribed. Same English it is. They're also paid up capital up to so and so, not exceeding so much amount as may be prescribed. So here it is how much? Does not exceed 25 lakhs or such higher amount not exceeding 5 crore as may be prescribed. The turnover of which, as per the statement of account and solvency, LLPs file a separate document which is called a statement of account and solvency. As per that, okay, during the preceding financial year, does not exceed 40 lakh rupees or such higher amount not exceeding 50 crores. Okay, so here the limits that you have to remember is first is 25 lakhs, second is 40 lakhs. Okay, nothing is given by the rule still. So the applicability for your exam will be you have to look at contribution should not exceed 25 lakhs and turnover should not exceed how much? 40 lakhs. So here the word used is and, same as that of small companies. Correct? So two things you have to look at. Contribution should not be exceeding 25 lakhs and turnovers as per the account and solvency should not be exceeding 40 lakhs. Maximum limit for paid up capital is, for contribution is given as 5 crore and then it has been given as what? 50 crores. 5, 50, 25, 40. That is the way you remember it. Okay, please remember it perfect. You would have a definition kind of question here where they would ask you to define a small LLP. Okay, important for the examination. And there could be some other terms and conditions which could be released by the central government. When they are released, you have to comply with them also. As of now, we have only two things. One is contribution not exceeding 25 lakh and turnover not exceeding 40 lakhs. That's the only two criteria. Your section numbers, please do not give much focus on. It's okay if you don't remember them. Now look at the definitions here. First definition, that is throughout the LLP, wherever they're using the word body corporate, you will not mean any body corporate. Like for example, we know body corporate means what? It should have a separate legal status. It should be registered, have a perpetual succession, correct? However, when you talk about LLP, all of these entities will not be considered to be body corporate. Okay? So your body corporate will simply mean Indian company, foreign company, Indian LLP, foreign LLP. Now, when you talk about a corporation soul, if you look at a cooperative society and all, they are also body corporate. But when you talk about LLP, they are not considered. Now, I'll understand why we are discussing this. After some time, we are going to understand who are eligible to become the partners in the LLP. And there the understanding given to us will be individuals and body corporate can become the partners. So that is the reason you want to understand that in case of LLP, what is the definition of a body corporate? Will any body corporate be allowed to become a partner? No. And that is the reason in LLP Act, they have given you a separate definition for what? Body corporate. That means for the limited purpose of LLP, only this is body corporate, nothing more than that. Correct? Okay, so look at the definition. It means the company under Companies Act 2013, that is now Section 3 of 1956, we don't consider. It has to be Section 2, Clause 20 of the Companies Act 2013 and includes an LLP registered under this Act, that is Indian LLP, a LLP incorporated outside India, foreign LLP, and a company incorporated outside India, that is foreign company. So I told you Indian company, foreign company, Indian LLP, foreign LLP. All the four are body corporate for this Act, but does not include a corporation sole, a cooperative society registered under any law for time being in force, and any other body corporate which the central government may, by notification and official gazette, may specify. How you have to remember this? Indian company, foreign company, Indian LLP, foreign LLP can become the partners. So they are body corporate. But a corporation, so like municipal corporations and all, they are also body corporates, but they will not be considered to be a part of LLP. Second is about a cooperative society. In audit, you study about cooperative societies, and we know they are body corporates because they're registered under Special Act. They are different from their members, okay? Separate existence in the eyes of law. So it is a body corporate, but for the purpose of LLP, they will not be called as a body corporate. Clear? And any other body corporate, if the central government passes an order tomorrow that this is not going to be a body corporate for LLP, that will not be a body corporate. Clear? Then we say that LLP should be formed only for business and not for charitable purpose. That means what is business here? Business would include every trade, buying and selling you can do, profession, CA, architects, anything is fine, service and occupation. So you can provide service in the form of LLP. You can provide a professional service in the form of in the LLP. You can also do trading of goods in the form of LLP. Absolutely allowed. Now, designated partners, we are going to study a separate concept altogether as per Section 7 of this Act, which is called as designated partner. We'll take it later. Entity. Entity means any body corporate. You have to skip the definition for entity. Financial year, you all know it very well. From 1st of April, it starts a 12 months period ending on 31st of March. Correct? However, you look at the sentence. Financial year in relation to LLP means a period from 1st day of April to 31st day of March of the following year. However, in case of LLP incorporated after 30th day of September, remember in Companies Act, the concept is 1st of January. So don't get confused here. When you study Companies Act financial year, you call it to be, if it is incorporated on or after 1st of January, then in that case, you can end it on the 31st March of the subsequent year. Here it is on or after 30th of September. So if 1st October also if you're forming, then you can end your financial year in the subsequent year. However, in case of LLP incorporated after the 30th day of September, that is from 1st October onwards, the financial year may end on 31st day of March of the year following that year. So don't get confused here. For company, 1st of January is the criteria given for this kind of situation. And for LLP, it is going to be recognized from 1st of October. Okay, so 6 months period you close, and then you're going to incorporate the LLP. You can close it on 31st March of the following year. Simple understanding, on 30th of September 2022, okay, or maybe 1st of October 2022, if you're incorporating LLP, you don't have to close on 31st March 2023. You can close on 31st of March 2024 also. So you can have a extended financial year. Clear? All right. Then the Income Tax Department has prescribed uniform financial year from 1st of April to 31st March of the following year. In keeping with the income tax law, the financial year for LLP should always be from 1st April to 31st March each year. See, now there has become a very big problem with regard to income tax compliances and all that. So though the LLP Act is allowing you to extend it 12 months period and make it 31st March of following year, Income Tax Department is not allowing it. And that is the reason through Income Tax Act, if you look at it, they require a uniform period of 1st April to 31st March. So only because they have to align with the Income Tax Department's requirement, you not see any LLP closing on 31st March of subsequent financial year. So even if they're forming on 1st of November, they will close on 31st March of the coming year only. Okay, so because that is the income tax requirement. Income tax is telling every year you are required to close for the income tax purpose. Okay, so is it allowed by LLP Act? The answer is yes. But are they doing? No. Why? Because they have to comply with what? Income tax regulations. Clear? All right. Then foreign LLP connect to companies incorporated outside India, having a POB in India. Same thing. It means LLP formed, incorporated or registered outside India, which establishes a place of business in India. POB should be in India. Then limited liability partnership, simple one. LLP means a partnership formed and registered under this act. So any partnership under the LLP Act is called as the LLP. Okay. So any partnership under Indian Partnership Act is called as a partnership. So any partnership under LLP Act is called as LLP. Okay, simple. Then comes to LLP agreement. You'll have two agreements. One is amongst the partner. One is between the partner and the LLP. And if both of these are silent, then you'll pick up the things coming from first schedule. It means any written agreement between the partners of the LLP or between LLP and its partners, which determine the mutual rights and duties of the partners and their rights and duties in relation to that LLP. Then comes to partner. Partner in relation to LLP means any person who has become a partner in the LLP always through an agreement. You know, when you talk about partnership also, if you want to become a partner, you cannot become by status. What is status? Like in case of Hindu undivided family, the moment you take birth in that family, you become the member. Okay, that means your birth itself, your status itself of in the family of taking birth in that family makes you the member. That absolutely does not happen in case of LLP. In LLP, if you want to become a partner, you have to be only through an agreement. There is no other way. Okay, so these parts I've taken very fast because they're very simple, and I'm very sure you know it because of your CA foundation base. Now, who can be a partner in LLP? Two possibilities are there. One is individual, other is a body corporate. So for individual, we are going to take something we study from the Contract Act. He should be a person who is a major. He should not be a person of unsound mind. He should not be undischarged insolvent. Okay, also understand, if you have applied for adjudication of insolvency and if the application is pending, even then you cannot be a partner in LLP. Okay, so these things will obviously be holding good only for whom? Individuals. But for body corporate, we see it as separately. So when you talk about disqualification, here they mean an individual or body corporate may be a partner in LLP, except unsound mind, undischarged insolvent, apply to be adjudicated to be insolvent, and his application is still pending. Simple it is. One is, when you're unsound, obviously you cannot. Second, already an order is passed against you to be insolvent, and the proceedings are still going on, you're undischarged. You're still insolvent in the eyes of law. Third is, there has been an application made to adjudicate you as insolvent, but the application is pending. So in all the three scenarios, you will be disqualified to become a partner in the LLP. Clear? All right. The following persons can become partner in LLP. Individuals, resident Indians, including non-resident Indians, and overseas citizens of India, as well as foreign nationals. Here there is no bar given. Okay, anybody can become a partner in the LLP. So it could be Indian resident, it could be a foreign resident, or overseas citizen of India. Okay, overseas citizen of India, non-resident and all. Here the criteria we're going to study after some time. Then one LLP can become a partner in another LLP. So one LLP can become a partner, that is allowed. Companies, including foreign companies, can become a partner in LLP. And then foreign LLPs can also become a partner in LLP. And foreign companies also. Now, can you see all this? See, italic one we know because individuals have to be there. 2, 3, 4, and 5 are nothing but they're talking about what? Body corporates. So look at that. LLP is a body corporate. So obviously one LLP in another LLP can be a partner. Company, including foreign company, is a body corporate, can become a partner. Foreign LLP is a body corporate, can become a partner. LLP incorporated outside India can be a partner, and then foreign companies also as a part of body corporate, so can be a partner. Correct? Now, in case of, so cooperative societies and corporations cannot become partner in LLP. Logically simple, because when you look at the body corporate definition, two exclusions are there. One is what? Corporation sole. Second is a cooperative society. When they are excluded from the definition of body corporate itself, then in that case, can they be partner? No. So obviously a corporation sole as well as a cooperative society can never become a partner in LLP. Clear? Then, in case of introduction of capital, acquisition of existing stake in LLP by persons resident outside India, other than NRI or OCIs. OCIs are overseas citizen of India. Okay, overseas Indian and citizens of India, investing on a non-repatriation basis. Then FDI compliances shall be undertaken by the LLP in which the investment is made. That means those who are, contributing to the capital, especially NRIs and OCIs, then in that case, they have to transfer the contribution on non-repatriation basis. So for that, we have the regulations made. Non-repatriation means once you send it, you cannot take it back. On that basis, you have to send it. And only then it is allowed. Otherwise, no. So what they say in case of introduction of capital or acquisition of the existing stake, that means either you bring in the capital or you are now admitting as a partner by persons resident outside India, other than NRI or OCIs, investing on non-repatriation basis. The FDI investment compliances shall have to be undertaken by the LLP in which such investment is made. Meaning is NRIs and OCIs have no problem. They can send money. I mean, they can acquire the stake. Obviously, it should be on non-repatriation basis. You cannot send it back. But apart from that, like foreign companies and all, then in that case, they have to fulfill which guidelines? Foreign direct investment, FDI guidelines have to be followed. Okay. So two criterias, NRI, OCI, FDI requirement not to be fulfilled. But when you talk about the others, like foreign companies and all, or foreign associations incorporated outside India, for them, obviously, in case of that, FDI requirements have to be fulfilled. Because you can understand their foreign direct investments. So regulations have to be fulfilled by them. Clear? All right. But NRIs and OCI should be investing on non-repatriation basis. That is important. Then minimum partners in LLP, you should have minimum how many partners? 2 partners. Correct? Every LLP shall have at least 2 partners. If the number of partners reduced below 2 and carries on business for more than 6 months, remember Companies Act, going below statutory minimum. So in case of public company, going below 7. In case of private companies, going below 2. You can continue like this for a period of 6 months. Till 6 months, whatever you do, limited liability is there. But after 6 months, if you still continue like that, then this is violation, illegal association. So all the activities after that, what you have done after 6 months period, for that you will become what? Unlimitedly liable. That means without limitation on the liability, you have to repay back everything. Same thing here. If the number of partners fall below 2, and this continues for how many months? 6 months. The person who is the only partner shall be liable personally for all the obligations incurred during that period. So after 6 months, whatever you have done, for everything, you have to be liable personally. So 2 partners required, 1 partner is gone, only 1 remaining. How much you can continue? 6 months. After 6 months, if you don't, then in that case, you don't bring in 1 more partner, then in that case, whatever activity you're doing now onwards, you will become personally liable. That is, attach your personal property to pay off the debts. Clear? All right. The designated partners, please mark it very important. Now, every LLP shall have at least 2 designated partners, and at least one of them shall be a resident in India. Compulsory. Every LLP shall have how many partners? Minimum 2 designated partners. And one of the designated partners should be in India. Here, so should be a resident in India. Here, the meaning of resident is you should have lived in India for a period of 182 days or more. Okay, now, provided if in LLP all the partners are bodies corporate, or in which one or more partners are individuals and body is corporate, at least 2 individuals who are partners of such LLP or nominees of such bodies corporate shall be acting as designated partner. What do you mean by this? Meaning is, suppose if there are 4 LLPs, these 4 LLPs have come together to form a partnership. Tell me, can one LLP become a partner in another LLP? The answer to that is yes. Correct? Now, in this case, what they are telling is, these 4 LLPs can come together and they can form an LLP. Now, in this case, is there any individual as a partner? No. All 4 are what? Body corporate. Earlier, this criteria was not allowed. Compulsory, you have to have individuals. Now they say if all are bodies corporate, then in that case, you should have nominees appointed. And these nominees will be acting as what? Designated partners. That is the criteria. Okay. If in LLP, all the partners are bodies corporate, or in which one or more partners are individuals and bodies corporate. So you have a combination of bodies corporate and individuals. At least 2 individuals who are partners of such LLP or nominees of such bodies corporate shall act as designated partner. Meaning is, bodies corporate cannot be calling themselves to be what? We are designated partners. No. Bodies corporate have to compulsory appoint 1 person to be the designated partner. I'll tell you logic also very simple. In LLP, if something goes wrong, if legal compliance is not done by LLP, then who will be responsible? Designated partner. And some places they're also given imprisonment. So how can you put a body corporate in jail? How can you make a body corporate liable? So because of that, they say even body corporate have to appoint whom? A nominee. And these nominees are going to act as what? Designated partners. Okay. So we have no problem if all are bodies corporate, but we require 2 individuals compulsorily. Be them actual individuals as partners or be them nominees of the bodies corporate. But they should then be acting as what? The designated partner. Resident in India, as I told you, a person who has stayed in India for a period of not less than 182 days during immediately preceding 1 year. If the incorporation document, after some time I'll be teaching you, incorporation document is like, how we have memorandum of association filed in companies. Like that, you'll have incorporation document in the case of LLP. So when you're going to file with the ROC, documents of incorporation of LLP, that time you don't file memorandum. You file what? Incorporation document. And in incorporation document, you're going to give name of the LLP, partners of the LLP, address of the LLP, business of the LLP, etc. That time you'll mention who are the designated partners. Correct? So that those will be acting as what? Designated partners. That is what they tell you. If the incorporation document specifies who are designated partners, such person shall be what? Designated partners on incorporation. Or state that each of the partners from time to time of LLP is to be designated partners. Every partner shall become what? Designated partner. So if in the incorporation document you're mentioning Mr. A and Mr. B are designated partners, then as soon as LLP is incorporated, A and B will become what? Designated partners. However, if you're mentioning, no, at every point in time, we are going to have different set of designated partners. Then in that case, on incorporation, every partner is considered to be a designated partner, unless you specifically appoint one or two. Then, any partner will become a designated partner by and in accordance with the LLP agreement. And a partner may cease to be a designated partner in accordance with LLP agreement. So in the agreement, you have to mention you're a designated partner. And if you do not want to be, through the agreement only, you will leave also. So there is no hard and fast rule. Once you are appointed, you will continue. There is all the option available to become also and to cease to be the designated partner. But everything will happen through an agreement. That is important. An individual shall not become a designated partner in any LLP unless he has given a prior consent to act as such to the LLP in such form and manner as may be prescribed. Meaning is what? Now, a designated partner is given a major responsibility that tomorrow if any non-compliance is there, LLP will not be caught, designated partner will be caught. So don't you think there has to be a person who's giving a consent to this? And after appointing him, consent is not required. You have to take consent before appointing him. So it is very simply understood that designated partners, before they are appointed as designated, they have to give a prior written consent to the LLP that they are willing to be appointed as what? Designated partners. Then, every LLP shall file with the registrar the particulars of every individual who has given his consent to act as designated partner in such form and manner as may be prescribed within 30 days of his appointment. So to ROC, you have to inform within 30 days that yes, he has been appointed as a designated partner. ROC should be aware of who is the designated partner. Clear? All right. An individual eligible to be designated partner shall satisfy such condition and requirement as may be prescribed. Nothing is given, only you have to understand that given in the rules, it has to be following as it is. Every designated partner of the LLP shall obtain a designated partner identification number called as DPIN. Same like directors will have DIN, director identification number. Here you'll have designated partners identification number from the central government, and the provision of section 153 to 159 of the Companies Act 2013 shall apply mutatis mutandis for the said purpose. Okay, so that is what they tell. If you look at it, designated partners once again, every LLP shall have two designated partners, one of whom shall be resident. If all are bodies corporate, the nominees have to be appointed, two as individuals. If you have combination of individuals and bodies corporate, then you appoint either individuals or you appoint nominees of the bodies corporate to act as designated partner. Resident means what? He should have lived in India for a period of 182 days or more. Okay. Then, incorporation document, if it is mentioning who is designated partner, they will act as designated partner. If not mentioned, all will become what? Designated partners. Designated partner should give a prior written consent that he is willing to become appointed as a designated partner. Then he can be appointed through the agreement. He can be removed also through the agreement. Okay. Then he has to fulfill all the terms and conditions that are required by law. And more importantly, he should obtain DPIN from central government, designated partner identification number. Clear? All right. Then comes to features of LLP. Now, these things are very simple. I will take you through very quickly here. I think we don't expect questions from here in the examination unless they're MCQ questions. So feature of LLP is a body corporate. Meaning is it is having a compulsory registration. So it is registered under the LLP Act 2008. Second, it has perpetual succession. Third, it has a separate legal status. Okay, it is going to have its limited liability. So it is fulfilling all the concepts of a body corporate. So LLP is a body corporate recognized as an artificial person in the eyes of law. Perpetual succession. Members, partners in the LLP and the LLP are different. So partners may be admitted, partner may be leaving. So existence, insolvency, incapacity of the partners will never affect the continuance of LLP. It will still continue. LLP is identified as a separate legal entity by law. So it is identified in the eyes of law, in the contemplation of law, it is a separate person. So it has a separate legal status. For the act of the partners, LLP will not be responsible. For the act of LLP, partners will not be responsible. However, you should understand that this is not going to operate every time. Sometimes act of the partner which is done in relation with the LLP, then they'll be having a mutual understanding also. There will be a kind of mutual agency present. Okay. Now they'll look at this. They're telling you mutual agency. That means in case of LLP, you will have no concept of mutual agency. That means act of one partner will not bind the LLP. Sorry, act of one partner will not bind the other partner. But act of one partner in relation to LLP will bind the LLP. You have to remember that. That means if a partner is doing something on behalf of LLP, then LLP will be responsible. So there is going to be a mutual agency between partner and the LLP. But partner and partner, no mutual agency. So act done by one partner will never be binding the other partner. But act done by one partner in relation to the business of the LLP will definitely bind the LLP. Clear? Then LLP agreement, I told you, the mutual rights and duties amongst the partner and the mutual right and duties of the partner with the LLP. All of this will be given in the form of LLP agreement. And if the LLP agreement is silent, you'll have the first schedule of the LLP Act to be followed. Then you have artificial legal person. LLP does not have an actual birth like you and I. LLP will be incorporated under law. It has a separate existence in the eyes of law. So it does not have an actual birth. So here they're telling it can do everything which an actual person can do, except for it cannot go to jail. It cannot take an oath, cannot marry, cannot get divorced, nor can it practice a learned profession, which you and I can do. So basically, it is not an actual person, but it is not even a fictional person. I always tell it is not a Spider-Man or a Iron Man and all that. They're fiction. They're not there only. But your LLP is there. Where? In the eyes of law. So we call this kind of person to be what? Artificial person. Artificial legal person. Common seal, not mandatory for LLP also. So we'll not call it to be a feature. LLP may or may not have a common seal. Okay, we'll have this reading once. Common seal, LLP being an artificial person can act through its partners and designated partners. LLP may have a common seal if it decides to have it. Thus, it is not mandatory for the LLP to have a common seal. It shall remain under the custody of some responsible official and it shall be affixed in the presence of at least 2 designated partners. If there is a common seal in the company also, always common seal will be affixed in front of 2 directors. Same thing here in front of 2 designated partners. If it is there. Then LLP has limited liability. That means every partner will have a limited liability towards what they have contributed, only that much. However, LLP will be liable to the creditors up to the amount they hold the assets. Okay. So whatever assets are there with the LLP, to that extent, for the liabilities, they'll be responsible. But will partners be personally liable? The answer is no. It is limited liability. Management of the business. In LLP, we don't have a concept of working partner, sleeping partner, all of that. So every partner has the right to take part in the management. More importantly, designated partners will be responsible for compliance of laws and regulation. Don't have an understanding, designated partners are going to run the business. No. Designated partners are not like working partners and all that. But designated partners are those where if suppose there is a non-compliance of anything, then in that case, definitely they will be held responsible. The partners in LLP are entitled to manage the business of LLP, but only the designated partners are responsible for what? Legal compliances. So all partners can manage, but legal compliances are interested only with whom? Designated partners. Minimum and maximum members. Minimum members are 2. Maximum are going to be unlimited. So in LLP, there is no limitation on number of partners. You'll have maximum is unlimited. Business for profit only, same like partnership. You cannot run charitable organization in the name of LLP. So LLP will be formed only for the purpose of profits, only for the purpose of business. And business could be trade, occupation, profession, okay, anything. But for charitable organizations, for charity, LLP cannot be formed. Then comes to investigation. Understand, LLP is governed by MCA and ROC. So anytime if ROC, MCA wants to conduct any investigation, can they conduct over LLP? The answer is yes. The central government may have the power to investigate the affairs of LLP by appointing the competent authority for this purpose. So MCA and all are nothing but departments of central government only. Correct? Then compromise or arrangement. Understand, if LLP wants to, if a private company wants to convert into LLP, if unlisted public company wants to convert into LLP, or if there has to be any merger, acquisition, amalgamation, all of these provisions will be done as per the LLP Act, not any other act. For example, if company is amalgamating with an LLP, okay, company is, like having a relation with the, 1 second. If the company wants to get converted into LLP, then in that case, those provisions will not be available in Companies Act. It will be where in the LLP Act. So compromise arrangement means that conversion into LLP firm private company, unlisted public company, as per schedule 2, 3, and 4. E-filing of documents. Today, there are no physical offices. So all the documents to be filed are to be filed with whom? ROC. And all of these will happen what? Electronically. So everything has to be done e-filing. We don't have the concept of physical form of anything. Okay. And all the signature will happen through e-signatures, digital signatures. Foreign LLP. What is foreign LLP? Incorporated outside India, having a place of business in India. So can a foreign LLP become a partner in Indian LLP? The answer to that is yes, because foreign LLP is considered to be body corporate. So foreign LLP can very much become a partner in Indian LLP. Clear? All right. Then comes to advantages of LLP. What are the advantages of LLP? Very simple. Organized and operates on the basis of an agreement. Very simple it is. Only agreement has to be formed and you will start it. Provides flexibility without imposing detailed legal and procedural requirement. I told you, company, the major problem is what? Procedural requirements are very heavy. In LLP, that is not there. So is it an advantage? Yes. Easy to form. All the partners are enjoying limited liability. Flexible capital structure. Contribution, they have not told any hard and fast rule. So capital structure is very flexible. And it is very easy to even dissolve. Correct? So look at that. Organize and operates on the basis of an agreement. And agreements are very simple, you know it. They are operating on an agreement. Second, does not have the legal stringent compliances, uneconomical compliances are not there, heavy compliances are not there. Very easy to form. Partners are enjoying limited liability. Then capital structure is very flexible. And when it is easy to form, it is easy to dissolve also. Clear? So that is regarding advantages of LLP. Okay, then. Next one, we have taken the next clip. Okay.